Commissioners, you are recording.
Welcome, everyone. Good evening to our first Board of County Commissioner meetings that will be occurring at Public Works, the first of quite a few. So this is our March 20th meeting. We have paper copies of the agenda, presumably, but I'm not sure where they are. Are they by the front door coming in? All right, and also, so if you need a paper copy of the agenda, it's there. The whole agenda and the agenda packet are always available online. If you need restrooms, because this is a new facility to many of us, they're straight through the doors just here. So for tonight, we did not have a study session, work session at 4, so we're just starting our business meeting now. We have a consent agenda with 9 items on it. We'll do our consent agenda, and then we will have general public comment. So if you've come to speak on a particular item, we'll hold for that item, but if you come for just general public comment, we will take that at that time. We do have a few rules that go with that. The first is that each speaker has 3 minutes. Second is that they can't donate unused time to another speaker. All comments must address topics relevant to the jurisdiction of our county commission, and reserve the right to mute any speaker whose comments are threatening, aggressively hostile, or belligerent. So when you do come forward for public comment, please state your full name and your Douglas County address. After we have general public comment, we'll move to our regular agenda. And how that works is we will hear from an applicant or staff, and then we will have questions from the commissioners, and then open that for public comment on that item, then bring it back to usually a further discussion and a vote. So with that, we have a consent agenda. Oh, I forgot to say, Commissioner Kelly is joining us online. So thank you for being here, Commissioner Kelly. And I will turn to fellow commissioners to say, are there any items from the consent agenda that you would like to pull for further discussion?
None for me.
This is Commissioner Kelly, none for me.
Okay, thank you both. Is there anyone in the audience who would like to pull an item from our consent agenda for further discussion? Seeing none, anyone online, Sarah, that you can see? Okay, with that, I would accept a motion for the consent agenda.
This is Commissioner Reed. I move to approve consent agenda items 1.1 through 1.9.
Thank you.
Commissioner Kelly, second.
Okay, moved and seconded. All in favor?
Aye.
Aye. Thank you. With that, is there anyone here present in the chamber who would like to come and give public comment? Come on up.
Hello, my name is Israel Barraza. I am not from Douglas County. I'm from Olathe, Kansas. But my name is Israel Barraza. I'm a junior in civil engineering at K-State. I'm also the president of Wildcat Wind Power. Wildcat Wind Power is a competition design team that competes against other schools at the Collegiate Wind Competition hosted by the United States Department of Energy. We have managed to excel within the past 2 years, becoming back-to-back national champions, and hope to repeat this year. As a team, we work towards designing a scale turbine to produce as much power as possible, along with ensuring that it is durable and safe enough to survive stress tests. Additionally, we develop model wind farms that must benefit the communities that they are placed within, and we work towards providing our community at K-State and Kansas at large with information on wind energy. With this mission in mind, we believe that Douglas County's current proposed setback limits could prove detrimental to efforts to reduce impacts of climate change and may reduce job opportunities for people like me and the members of our team. Climate change and its effects on our future lives is something all the members of Wildcat Wind Power and much of our generation care about deeply. Among the largest contributors towards climate change are energy generation and industrial energy demands, and we believe that wind power and other renewable energy technologies are crucial to reducing the effects of these industries on climate change. Prior to becoming the president of Wildcat Wind Power, I was one of the project development team leads, and I worked extensively with placing turbines at an appropriate and safe distance from each other and people. Through our research, we found that the industry standard for wind turbine setbacks from property lines is approximately 1.5 times the height of the turbine, with many states such as Texas holding lower requirements. Kansas currently has no statewide requirement, leaving counties able to set their own requirements. They can adopt regulations that are based on science and engineering standards that are safe and supportive of renewable energy, or they can choose arbitrary numbers based on what-if-isms and effectively ban wind energy. Among Kansas counties, no county with setbacks as excessive as those proposed in Douglas County has a single operating wind turbine. And based on the average height of 357 feet for wind turbines, Douglas County's current proposal is almost 210% over the industry standard. With all that in mind, I urge the County Commission to reconsider their setback limits to allow wind energy to be introduced in Douglas County and provide for the needs of current residents and the future generations that will live with the decisions made now. Thank you.
Thank you. We have anyone else? Come on up.
Good evening. I'm David Pearson. I am from Nemaha County, Kansas, and I'm currently a senior in electrical engineering at Kansas State University and the electrical team lead for Wildcat Wind Power. Through my study of electrical engineering and experience with Wildcat Wind Power, I gained a passion for working towards a sustainable grid. The last 2 summers, I've had internships with renewable energy developers focusing on the construction of wind and solar plants along with their associated transmission infrastructure. In this experience, I've seen the detrimental impact that excessive turbine setback regulations have on the ability of companies to bring clean energy to a county. Large setback distances are the fastest way for wind projects to become unfeasible across an entire county. I would highly encourage you to consider setback distances for turbines from non-participating landowners less than the proposed 2,500 feet, as this would effectively eliminate the possibility of wind energy in Douglas County. Renewable energy projects in Kansas provide stable careers to my generation that allow us to actively fight climate change, an area that is of immense concern to us. My recent job search experience showed me the large interest that renewable energy companies have in hiring homegrown talent. They view being from Kansas as a tremendous asset because we have a great feel for how to execute community-friendly, clean energy projects in an area with a tremendous wind resource. After graduation this spring, I will go to work as a transmission engineer, working on a clean energy power line traversing my home county in Northeast Kansas. This is a story commonly seen in my friends and classmates' lives, Kansans benefiting from stable and fulfilling careers from renewable energy projects right here at home. As you evaluate turbine setbacks, I'd ask that you consider the impact your decision has on the next generation. Thank you for your time.
Thank you. Do we have any others? Anyone else who'd like to give public comment? Come on up.
So I've got my sign here. We're tired of the tax increases. Okay? And they want to blame it on the, I'll turn it around here so everybody at home can see. They're trying to blame it on the escalation of property values. But it's also your spending. You guys are spending way too much money and you're expecting people that can't afford to pay their own rents and their own food bills to continue to fund this excessive spending spree you guys have been on. Part of that excessive spending spree is attorney's fees that you're spending to defend lawsuits for throwing people out of commission meetings for carrying a sign like this. I want to point out to everybody in the room, it looks like they may have learned their lesson, haven't they? That a sign like this doesn't get you thrown out of a commission meeting anymore, does it? Is that because your attorneys have told you you can't do it at the cost of us taxpayers? I appreciate the fact that you're able to sit here for 3 minutes and respect the people's time to speak. We're tired of paying your excessive bills. Once the attorney's bills are paid and that's taken care of, we need to address the county spending as well. Because we're spending way too much. And the last thing before I leave, I like what they said. Your setbacks at 2,500 feet and that ice throw stuff, come on, guys, come on.
Thank you. Do we have any others for public comment? Sarah, do we have anyone online? All right, with that, we will close. Oh. All right.
Carrie Brandon, I'm moving you into the panel for public comment. Carrie, you're in the panel. You can provide your public comment.
Carrie, if
Carrie?
you want to come off mute, you can give public comment. If you're not interested, that's okay too.
No, I'm interested, Karen. Thank you.
Okay, go ahead.
Good evening, Commissioners. Terry Brandon, 2300 Road, Douglas County. I want to make public comment tonight on consent agendas. And I'm not sure exactly what, I know you guys have a lot of study sessions, right? And there's a lot of conversations that happen between just you all and staff and, other outside partners and people that come into the study sessions. However, the public does not really understand or have visibility to all of the study sessions that you have and how well you've vetted things before you're voting on consent agenda items. So for example, what he was just saying about all the excessive spending, I know we have budgets and all of that, but take, for example, we had how many consent agenda items tonight? There was, I don't know, probably 8 at a minimum. I need to count them. A lot of them were public works, right? Some of the public works consent agenda items were, in excess of $1 million. And, when I'm reading the agenda item, the consent agenda item example for like public works through Chad Voigt, one, for example, is the bid on aggregates, and then there's paving, et cetera. And the bid process, it looks like most of the time, hopefully that's at least 30 days long. And then it doesn't say under the published whether or not you guys are how you're publishing. It just says dates that it was published. Sometimes it'll say it was in Lawrence Journal World. But do you all ever like benchmark what you're spending with these recurring contractors and then actually send out letters to request bids versus just publishing it? And I'd love to know where it's published and not have it be vague on these consent agenda items. But what I'm trying to say is consent agenda, you can sometimes really abuse it and, pass things through really quickly. That took all of 15 seconds to vote on the consent agendas. And there's a lot of budgetary items in there that you perhaps maybe were well vetted and everything is understood because of your study sessions, but maybe not. And an example of that is my question to Commissioner Reed, my District 2 Commissioner, about the, the 7-party agreement for the Southwest Metro Area Transportation Connection Plan. That got on as a consent agenda item, right? And I asked Shannon when it was coming before the commission, she didn't know what it was. So this tells me that major transportation plan that involves County Line Road all the way to 1060 Highway in the study area, you most likely you weren't even aware of what it was because perhaps administrative staff, Sarah, did not thoroughly educate you on what it was because Shannon didn't even know.
Carrie, I'm not sure if you can see the signs because we're kind of getting used to our new system here. So we've come to our 3 minutes.
Tiny. Anyhow, I would love a response to my email to all of you. And then I don't see that Sarah put my email on public comment on the agenda packet. I'd like to know why.
So Carrie, we've come to the end of our time there, but I would flag that for every meeting that we have a consent agenda, we open that to the public if anyone has an item they care to pull, and we didn't have any this
I know
evening.
that.
So,
yeah, Karen, I realize
thank
I
you,
don't want
Carrie.
to pull it. I don't
Sarah,
want
do
to
we
pull it
have
this
any
time.
other?
Oh
Do we
my
have any other online
All right.
commenters? All right, thank you.
So disappointing.
So with that, we come back to our regular agenda meeting, regular agenda, and we have a planning item to start off. And there's Mary Miller in person.
See if I can find my, I'm just going to pull up a copy of the site plan that's the subject of this extension request. There. So Mary Miller, City County Planner, and this is a extension request for a site plan for Phase 2 of Veritas Christian School. The site plan was approved in 2022. It has a 2-year period, at which point a building permit must be pulled or the approval expires unless an extension is requested. So I'll give you just a little background on this school. Phase 1 of this school was submitted, the site plan was submitted in 2018, and that was for the gymnasium and the parking area to the west, and that was approved in early 2019 and was built.
For a second, I think I need you to share that screen in Zoom.
Oh, I
Um,
think I would know how to do that. Let's see.
So like it's on this screen, but I'm not seeing it on Zoom. So does she need to, from the commission Zoom?
Arrow there.
Yeah, now go to share screen. And then pick your site plan.
I
you
remember
go.
that. Thanks.
Yep.
I think you can see it
Then you
now.
can kind of, if you, you shrink the long thing over there under the little line, nope, keep going over to the right, up at the top of the commission one, the smallest little line, it minimizes it. Yeah, hide that. There you go. And then she'll see more. If you kind of stay below it, there you go. You can drag it around. Thanks, Mary.
Okay, so this, the early one, Phase 1, was for the gymnasium and that parking area to the west. And as we were reviewing this, staff was concerned that there weren't any classrooms. It was just a gymnasium. There was concern that it might just morph into an unofficial sports recreation facility. So a condition was added, or a note was added to the site plan that this was for school use only, and if it was going to be used for public recreation, either a special event permit or a conditional use permit would be required. Then in 2021, a site plan for Phase 2, and this is the site plan for Phase 2, was submitted, and it included modular classrooms to the east. There was a walkway from the classrooms into the building, a future locker room, there's a fire access lane, and then an expanded parking area to the south, as well as oxidation ponds, which are typically called lagoon system for sanitary waste management. This was submitted in 2021, and we went through the process. A different consultant was hired for Phase 2, and he identified an easement, a KDOT easement that had not been identified earlier, and it wasn't on any of our records. So actually, the gymnasium was built over a KDOT flowage easement, which I assume is something like a drainage easement. So the consultant worked with KDOT and prepared some studies showing that that easement could be reduced. And KDOT agreed that they would reduce the easement so that there was no encumbrance of the building. So the site plan was approved in March of 2022 based on KDOT's agreement, but KDOT didn't actually reduce the easement until September of 2022. So that site plan was held in the planning office until then, and they could not apply for building permits. So that was the delay in construction. So during that delay, they did apply for a conditional use permit so they could get a little bit more use out of their gymnasium, and they wanted to open it up to other schools or clubs. And so that CUP was approved for 10 years because once this is a school, those kind of uses are just accessory. They wouldn't need a CUP at that time. And this is a very limited CUP. It allows practices, no games, no tournaments, and it has a limit on the number of players and coaches and the number of practices per week. So that CUP is in place and that's ongoing right now. But the delay until September of 2022 made it to where they could not build their school in time for the school year. So they entered into a contract with a church in Lawrence. They had sold their property. They entered into a contract with a church to have their classrooms there. They still do their athletic uses here. So the applicant could explain more. I don't know what the terms of their contract is, but I know they're currently in this church with their classrooms. And so that's the reason they're asking for an extension, is they just haven't had time to get out and do the construction work. So the reason there's an extension process with site plan approvals is that after 2 years, if it hasn't been built, we want to reevaluate and make sure it's still compliant with building codes, fire codes, the zoning regulations, any other county codes, to make sure the site design is still appropriate. And so we didn't find any changes in code that would make this an inappropriate site plan design. So staff is recommending approval of the 1-year extension. And I believe the applicant is present today. I think he's attending through Zoom. Yeah, Aaron Jaspers.
Have an Aaron Jaspers to move into the panel? Thanks.
That's a good question.
Hello, Aaron, if you'd like to address the commission, you can come off mute.
Yes, sorry, little technical difficulties getting on, but can you hear me?
We can, thank you.
Okay, Aaron Gasper, CFS Engineers, and yes, here representing the owner as well. And yes, thank you, Mary. She pretty much covered everything. The school itself is still working through details, basically where they plan to be long term, and they would like to keep this site plan down at this gym as an option. So thus the need for the extension. So I am here to answer any questions you might have, and thank you.
Thank you. Commissioners, do you have any questions for Mary or for the applicant before we do public comment?
I do not.
Would you care to, or if you'd like to come up and address us?
My name is Becky Chapman, and we live out there. And I was just wondering, when you had that picture up, are they going to be adding more parking? Because now they're parking out on the highway, the road, when they have big events and lots of people. And I was just curious if they are going to be adding more parking. That was my only question. Because it's kind of a safety thing when they're out there parking in bad weather and then the ice. But anyway.
Okay, thank you.
That was just my question.
And before we get to that, is there anyone else who'd like to make public comment on this? Or anyone online? Okay. That we're closing public comment and bringing it back to the commission. I think that's an excellent question. Mary or Aaron, would you care to address the parking? I have noticed that a lot of the parking does occur on the side of the road.
Yes, Aaron with CFS. Yeah, as part of that plan, they are aware of the parking issue, and as part of that plan, they do want to expand the parking lot on the property.
And Mary, I wondered if you would put the drawing back up, the site plan? And we'll try.
Oh, it's right there, but I need to share a screen. Okay.
Thank
So
you.
this would be the new parking area that they're planning on adding.
And would that parking only be added if the classroom space is also added, or would the parking possibly be added just because the need is already there?
I'd have to refer to Aaron for that.
To Aaron? Okay.
Yes, I believe either way, they want to expand the parking.
Okay, thank you. I think there's a neighborhood interest for that. Thank you, Mary. Commissioners, do you have other questions or comments?
None from me.
Okay. With that, I don't have any issues with, given the circumstances, extending for another period of time, and I'm glad that the parking is part of a discussion and that there's been some feedback from the neighborhood also. I would entertain a motion if anyone wanted to.
This Commissioner Reed, I move to approve a site plan extension request SP-21-00404 for Veritas Christian School located at 960 East 1296 Road.
This is Commissioner Kelly, second.
Okay, we have a motion and a second. All in favor?
Aye.
I assume that. There we go. Thank you. Thanks. So then the next item is an update from Kansas Holistic Defenders. And will we start with Sam? Okay.
Sam, I'm moving you into the panel, so as soon as you can accept that, well,
Terrific.
I can do it again if you didn't have it.
I've got it.
Oh, you got it, great.
Make sure this is up for presentation. Oop. Yes, here we go. And I've never wanted a longer county commission meeting, but we thought we were going to be a little later in the presentation, so we may have some guests coming to watch during the presentation. Very excited to present for you all. Is that coming through all right? It looks like it is. This week marks the 61st anniversary of Gideon versus Wainwright, the Supreme Court case that established the right to a public defender. And this year also marks the second year for Kansas Holistic Defenders. And the first 2 years of any public defender's office in Douglas County. And we're very excited to think that we are honoring the legacy of Gideon in the information that you're going to see today. So, who are we? I'm not going to go too deep into this. Nobody knows better than you all what the purpose of our organization is. But for anybody who doesn't know, we are Kansas Holistic Defenders, a holistic public defender office here in Douglas County. What that means is that we combine excellent representation in court with also resources that are intended to help clients both complete their requirements in court, but also to access services and benefits that are necessary to address the root causes of involvement in the legal system, to correct for racial and other disparities in the legal system, with the intention that by having an institutional defender's office, we can resolve cases more effectively, more quickly, and having a lasting impact for those who are affected. Our mission is to defend Kansans effectively, zealously, and respectfully, using an interdisciplinary holistic approach to champion our clients' individual goals and address the root causes of involvement in the legal system. And so turning to who on our staff is employed as a result of the county contract. We have me in the middle. I'm the executive director of litigation. I both perform the supervising role at the office, and I'm on the front lines myself in court. We have Julia Parker, somebody who I cannot say enough good things about, an incredible investigator with a background in social work, who helps us dig for the truth in each of our cases. Robert O'Connor is one of our attorneys who came on with us at the end of 2022. And then we also have Madeline Calcagno, an outstanding KU law graduate who joined our office in August of last year. We have Santiago Vasquez, our client advocate, who just today was helping first a client get her vital documents like her birth certificate and ID, and then drove out to Artists Helping the Homeless to get a client property that had been left behind after we had helped get him into that program. And of course, my wonderful co-executive director, Tamber, who is here, our executive director of operations. This position was created using funding for an administrative role that we turned into a co-executive director role with some outside funding to essentially oversee the operations and business aspects of our work. So these 6 staff are all funded through the current contract. So turning to the demographic breakdown, we have 2 graphs here, one of them showing the gender breakdown, where we have male and female. We had one non-binary client that was represented here as well. And you can also see the demographics of our clients racially as well. The majority of these being white. And for perspective here, the pie chart is a little bit easier to see the breakdown you'll see that a very large segment, particularly of our male clients, 1 in 4 roughly is Black, with a large segment being comprised of Hispanic or Indigenous or other non-white categories. Here we compare the overall racial breakdown of our clients to the county, and we see that there are still some very significant disparities, overrepresentation of Black and Indigenous people significantly relative to their share of the population of Douglas County as a whole. Black people in Douglas County are roughly 6 times as likely relative to their population to be charged in Douglas County as their white counterparts. And this is a persistent racial disparity that continues to exist. Obviously, the Vera report that came out some years ago doing a lot more analysis on this, but it is useful to keep this in mind going forward when we look at outcomes. Turning to some other metrics, we have the attorney caseloads here. Now, this is not an average. This is a point in time count, but it does give you a picture of where our caseloads are at. And you'll see that these are broken down into 3 different categories. You'll see that the vast majority of our cases are marked as open. These are pre-disposition cases that are still pending. We have a smaller proportion, roughly between 5 and 10% of all of the cases that we handle are what are called probation violation cases, where we're assigned to represent people who are already sentenced, serving a sentence on probation, where something has gone wrong and they are now being violated on that probation. And then we also have a significant number of our clients who are on track for diversion. We do track these separately because those are not cases that are heading to litigation. These are cases where there will be a contract between them and the district attorney requiring the completion of community service and treatment or other programming in exchange for a dismissal of the case after a year. You can see that I continue to have the highest caseload. This is in part because we made a decision when Madeline came on to not transfer existing cases. It's better for both her development as an attorney and for our clients to have continuity of representation. But since she's coming on in August, she has gotten what is now a full caseload. Robert O'Connor slightly lower because he was on medical leave for a period. And so those are coming up. Important to note here that our contract with our employees, with our attorneys in particular, caps cases at for line attorneys at 90 per attorney. This is consistent with the nationwide recommendations for caseloads of public defenders. You will no doubt have heard that a big problem in public defense is having too many cases to do a good job. We want to make sure that doesn't happen. Even if these cases were sort of averaged out over everybody, would be slightly over our target caseload for attorneys, which is important because once we get above that, it becomes very difficult to do our best work for our clients. Turning to case outcomes, this is the part that I'm most proud of in the whole presentation. You can see that we've got 2 different ways of looking at this, both on the level of the case as a whole, and then we'll also go into the individual charges within cases, which gives us a little bit more granular way to analyze this. But you can see that right now, the most likely outcome for our clients is a dismissal. The majority of those dismissals of charges are coming from litigation. That is, cases that we are fighting either through motions to dismiss, motions to contest the constitutionality of evidence that has been obtained. We're taking cases to trial that are then dismissed. A smaller number of those charges, but still a significant one, is charges that are dismissed as part of a plea deal, right? Plead to one charge, will dismiss these other 2. And also important here is diversions. And if you add together the dismissals that come from litigation, the dismissals that come from a plea deal, and the dismissals that come from diversion, you see a very large segment of our cases, and we'll go into what this is, are resulting in our clients, in charges being dismissed for our clients. Cases that do not get dismissed most likely will end in some form of a plea deal, where, and we'll talk about what the outcomes of those things mean. You'll also see a couple other categories we'll get into. Open pleas, that is where we don't have a deal with the prosecution, we plead as charged and make an argument to the judge for sentencing. We've also had 3 clients enter behavioral health court, 2 charges that were acquitted at trial, 1 that was found guilty at trial, and 1 that is that we won. It was dismissed, but the state is appealing it, so we wanted to mark that differently. So if you look overall, that was the charges view. So looking at individual charges, it helps to look also at cases and what's happening overall. And so you'll see that 43% of our cases at the end of our representation are dismissed in their entirety, with another 20% being going through a diversion process, where at the end of that diversion process, roughly 92% of clients that go through diversion with us are getting a dismissal as well, which means that for about 63% of the cases that we handle, the individual represented is walking away with nothing whatsoever on their criminal record as a result of our representation. Then we have the outcomes broken out in 2 other ways. Probation represents people who are put on probation, and post-conviction refers to individuals who are have some amount of jail time as the result of their case. And you can see that we've also broken this down by race. This is a bar chart that shows essentially where the dismissals are coming out of. You can see that for Black clients in particular, a higher rate of dismissal than other demographics. There are many reasons for this, but I think a lot of the time it is because it's because the charges should have never been brought in the first place, and Black people are more likely to be wrongfully charged due to a variety of systemic reasons. You can also see that that is also true for our Indigenous clients as well, which means that our goal is obviously to win for each and every client, but our hope is that by vigorously fighting every case, we are able to make sure that we are a check on the racial and systemic biases within the system. Turning to what happens on these plea deals that some of our clients receive. So you'll see that roughly 68% of plea deals are a recommended sentence of probation, with another 32% being for jail time. The second chart here, I think, is really important because oftentimes we go in without an agreement with the prosecutor, and this is often because they are asking for jail time, we're asking for probation. So you can see that when we go in without a plea deal and have leave it up to the judge about what to impose based on our sentencing recommendations, more of our clients are getting probation there, which shows that I think sometimes that approach can be very fruitful for our clients, where the deal offered by the state is not as good as we could ultimately get from the judge by pleading open. So when we say jail time, let's break down what that means. On average, where clients are sentenced to jail time, they are sentenced to 30 days in jail. Now, this is in some ways a difficult statistic because there's a huge range of jail time that people face. It averages out to 30 days. 90% of our clients who are sentenced to jail time are sentenced to time served. That is, they had already served a period pre-trial, pre-disposition, pending an outcome, and the ultimate sentence is that they be released with the time that they served being sufficient. The other major driver of folks that are not sentenced time served are where is a mandatory minimum. So for instance, in second-time DUIs, there's a mandatory minimum of 48 hours in jail and 3 days house arrest, which in most cases cannot or will not be served pre-trial. And so people stepping into the jail after sentencing to serve a sentence are typically for a second-time DUI. The vast majority of jail days, especially the clients who are driving jail days in terms of 90, 180, 200 days, are waiting for competency restoration. They are individuals who are experiencing mental illness at a level that makes them unable to participate in their own defense, unable to participate in court proceedings. So we have to wait for competency restoration, which typically means that person has to get in line to go to Osawatomie State Hospital, and the waiting list for treatment at Osawatomie is several months long typically. And so if what would drive down the jail days most for us would be if there were fewer days required to be sent to Osawatomie. I know now that the county has just started a in-county competency restoration program. Could not be more excited about that. I think in next year's numbers, we're going to see very different jail numbers if that program is successful, because competency, basically, the county has done so much in terms of pretrial release and other services that make it so that detention is not necessary for most people pretrial. Virtually the only people who cannot get out on pretrial release for a misdemeanor are individuals who are in such crisis that they need competency restoration, or some other unmet need means that they cannot be released as they are. So turning to a couple other things I wanted to mention in the outcomes. With those dismissal numbers, about 45% of our cases being dismissed. I think we're getting fairly close to the most number of dismissals that we could possibly get, right? There is obviously going to be a limit on how many cases can get dismissed. Last year, that number was 35%. And this year, it's 45%. That's a 25% increase, which shows that we are getting a bit better as we go on. Here we have the length of cases also is quite important. And so we've broken these down into the number of days to resolution and the number of court dates. So the chart on the left is how many times somebody has to appear in court to get a resolution. For instance, here, someone will on average go to court 3.5 times before getting diversion, and 5 times before probation. Couple reasons I think we see these numbers. One is that anything that has a plea deal or a plea and sentencing phase will have, by definition, an additional court date. Additionally, the number of jail days is the number of total days from case start to final court date is really important. And I should note that this is the one area where we are less good than we were last year. So last year, our average number of days to resolution was about, depending on which category you're talking about, 20 or 30 days faster than we are now. We're looking into the reasons why this might be. There were some significant, sometimes there are delays from the state in terms of processing diversions. We had some staffing issues. We want to keep, the other reason is that now we're also getting probation or diversion violations from cases that we originally represented, which adds another court date, perhaps a year after the last one. But we do want to keep track of this number to make sure that this is not a trend going forward and that we are moving as quickly as we can, while still representing our clients as effectively as possible. Some other metrics of the holistic aspect of our program I think are important to address. So We have made 68 referrals in the reporting period. I should also mention this reporting period runs from September 22 to September 23. The reason for that is because our last presentation was measured from September, but additionally statewide, the court system, the court electronic filing system collapsed entirely and was unavailable in October, which made validating some of our data, right? Like comparing our data to what is in the court records more difficult for the period after September of last year. But what we've been able to determine is that we had 68 clients that we referred to drug or alcohol assessments, and often in 99% of those cases, those individuals are also then being referred to for treatment, whether that is an 8-hour class, outpatient or inpatient, as may be necessary. We also had 15 motions to transport individuals to inpatient treatment. This is really significant because these are all individuals who were in Douglas County Jail, who then were accepted into an inpatient program, and while still under Douglas County custody, were transferred from a jail environment to a recovery environment. This, I think, is helpful to the county in terms of reducing our reliance on the jail, but also making sure that people's pretrial detention phase is not just wasted time, but is rather something that's going to help them achieve long-term stability. We also had 15 clients that we referred to immigration service consultations as part of what the county funds. We work with the Sharma Crawford Clinic to make these referrals for individuals whose immigration status means that we have to pay special attention to the outcomes of their cases because of those collateral consequences. It bears mentioning that each year we are funded for 15 of these referrals. I think good news is that's right on the money. Of course, in other years it may be higher or lower depending on who comes through our door, but that is also a good sign. And finally, we had 30 individuals who were referred for domestic violence assessment services. And again, the vast majority of those then also being referred to either anger management or batterers intervention program as part of condition of probation or diversion. This is, I think, one of the more interesting parts of the presentation. So we have all of these metrics of our impact in terms of how we're doing in terms of resolving people's individual cases. We don't have a comparative value, right? We don't know what would have happened to those people were they to have received, if we didn't do our best work for them. Probation violations give us a sort of unique opportunity to assess our impact. And the reason is because each person who's placed on probation is given an underlying sentence of 3 months, 6 months, a year in jail. That is the amount of time that they will serve if they're violated on probation. And during this period, we were primarily being assigned to people who we did not represent on their initial case, but were rather, they were perhaps had a case that resolved in 21 or 22 and are now coming in on a probation violation. And each of those individuals has an underlying sentence that they will serve if their probation is revoked. And so this gives us a really interesting way to evaluate our impact because we can see exactly what would happen to people if they are revoked on probation. And so when we get these cases, a number of things happen. Either we help them get in compliance with probation, which means they are either released from probation or they are reinstated to an additional term of probation without going back to jail. They may be resentenced, right? They are somebody who just is not going to be able to be successful on probation. We ask the judge to resentence them to an amount of time that is less than their underlying sentence, that is a more reasonable, fair, and just amount of jail time for them to serve. And so of those individuals that we represented on probation violations, 9 were released from probation, 15 were reinstated. And then in terms of people who had some form of jail time, 2 were resentenced from a term in the Douglas County Jail to house arrest. 3 were reinstated to probation after serving some amount of jail time, and 13 were resentenced to serve less jail time than their initial underlying sentence, and only 2 were ordered to serve their full underlying sentence. So what does this mean? Well, what this means for the county is that each day in jail costs the county roughly $226.15. This is an estimate that I got from the sheriff's office. And so what we did is we took people's underlying sentence and compared it to the number of days they in fact served in jail at the end of our representation to measure how many days were served as a result of them either being reinstated or resentenced. And ultimately, we saved 9,431 days of jail time. That's roughly 24 years of human time in jail. And crucially, for the county, that means a savings of $2,132,821. And again, these probation violation cases are only 10% of the cases that we represent. And so this is to say that the numbers would indicate that having attorneys at first probation violations with the holistic model is money well spent by the county. Turning now to what we do outside of the criminal realm, we also have a legal team. It's a civil legal team. We have a legal team, but we also have a civil legal team, some of which are here with us today. We have the phenomenal Rebecca Gaston, who is both a frontline attorney and supervises our civil program. We had recently hired in October Hetty Pierce Armstrong, another KU Law graduate who comes out of a labor law background, and Mariah Kennedy, our paralegal for the civil team. And this civil team has two wings, one of which is based here in Douglas County. In 2023, we received a grant from state money, Access to Justice, to do civil legal services here for Douglas County residents, which is being handled by Rebecca Gaston. And since October of last year, she's done some phenomenal work for the residents of Douglas County. We have had 25 eviction cases, 5 debt defense cases. These really make my stomach turn. They are often big companies who file thousands and thousands of these for debt collections, often which are either fraudulent or overstated or violations of the Fair Debt Collection Practices Act. Most people don't get an attorney for this, don't even know to contest them, and then end up with judgments of thousands of dollars hanging over them. We've done 2 expungements. We've done one in another category. And then in addition to where we provide full representation, we also do limited representations. So that is working with the Douglas County Self-Help Office to get referrals for them. Questions the Self-Help Office needs an attorney to answer for somebody, we help answer. And then we also have 4 which are pre-eviction cases where an eviction case hasn't been filed, but we work to resolve these. In the reporting period for evictions, we completed 20 eviction cases. We completed 3 debt defense cases. And I want to talk to some of the successes there. Also of note, the debt defense, the 3 cases that we've completed, we won completely for our clients, saving Douglas County residents and our clients $21,000 in judgments that would have otherwise been levied against them. So turning to evictions. Of the 20 eviction cases that we closed, 17 were either dismissed or found substantially in favor of the tenant. And this typically means that an eviction was averted as a result of our work. And where evictions were ordered in 3 cases, 2 of those clients, because they had an attorney who was fighting for them, were able to get over a month of additional time to move before the eviction, which means that those individuals did not become homeless. They were able to set up a new place to go. And this is a really significant win for showing the power of attorneys in eviction cases, averting homelessness. Really, really proud of this. Would love to see more. Additionally, we have our Topeka Family Legal Project. This is another grant-funded position that Hetty Pierce Armstrong is primarily handling a pilot program in Shawnee County to provide free legal services to families who are at risk for child in need of care or other sort of DCF involvement, which we're very proud of. Another very huge thing that happened in public defense last year was that the Board of Indigent Defense Services, the statewide system that does defense for felonies, established a Douglas County office. They have been incredible partners to have in our county. We have partnered with them on staff trainings. We have partnered with them on cases. We share best practices. We helped them set up their program for meeting with clients ahead of first appearances, the way that we do. And we've code counseled a number of cases with them. Everyone in that office is phenomenal. We're very grateful that they were able to get set up as well, which means that in Douglas County, there is now institutional representation for both felonies and misdemeanors. We are the first county in Kansas to have that, to have both. So turning to sort of the takeaway here, in terms of our goals for service provision, we are able to help meet our clients' goals in at least one aspect of our holistic representation 90% of the time. We have improved our litigation outcomes, increasing our rate of dismissals. We have continued to improve in helping people meet the requirements of diversion and probation, deepen our relationships with the community partners, and helping to reduce our overall racial disparities in the system. The areas of growth, which I'll go into for the next couple of slides, are we are still struggling with the category of client that makes up the majority of our jail days, people who are off the charts, high needs in terms of either mental health, drug treatment, or other services that are needed that are very difficult to provide without a social worker on staff. We would like to increase our ability to provide wraparound services. We can make service referrals, but do very little of it. Well, not very little, but we would like to do more in-house for our clients. We do want to develop more in-house data collection efficacy. In particular, we are submitting a grant to Arnold Ventures to conduct a study that will compare the efficacy of Kansas Holistic Defenders to individuals who received panel attorneys in the periods of the study period where we were not taking cases. And that would also allow us, if we got that grant, would also fund a position for data management within our office, allowing us to do even more of this kind of analysis or potentially help the county with data analysis around criminal justice issues. So the needs going forward for the next year fall in two categories: wage increases and the need for a social worker. One of the biggest reasons that we were talking about wage increases is our staff unionized in 2023. We are the first unionized public defense office in Kansas, and our staff unionized with the Teamsters. We have, I believe, a Teamsters representative here. Teamsters represent public defenders in a lot of different places all over the country, and working with them as partners and making our office as strong as it could, we bargained our first contract, which meant a solid package of wages, benefits, case caps, and protections for our workers. Since we had our budget for salaries in 2021, obviously inflation has increased tremendously since that time. Real prices are up 12%, which means that the money that we have for salaries now in real terms for our workers is 12% less in their pocket than when we first opened our doors. Our attorney caseloads remain close to or above sustainable levels. We are very eager not to stop taking cases to address that. We're looking at ways to get additional staffing on to make sure that the caseloads are at sustainable levels for the long term. And it's a very tight labor market. It remains a very tight labor market. And so in order to be competitive, other offices, for instance, BIDS last year did get more funding from the state to provide for wage and salary increases for both their attorneys and their support staff, which means that in order to hire people, we are competing against a higher wage now than when we first started in 2021. And if we're able to provide competitive wages for our staff, that means that we are hiring the best people. It means that we are retaining people who are already here. I would hate to lose absolutely anyone that we have on staff because they are all incredible. So something to keep in mind for the next budget cycle. Additionally, we are continuing to ask for a social worker as part of the package of services that we are to provide. Social workers remain a key component of the holistic model. I know that at the time that we were first established, it was unclear as to whether or not existing social work and access to those types of services were sufficient. I think that our experience has shown that there really is a need for a social worker on staff at our office. The mental health services that exist are still quite difficult for many of our clients to access, especially the population that we represent of folks who are also charged with crimes. A great number of our clients are banned from other service providers, and so we have to often go out of county or help facilitate them accessing providers out of county. We have, with people who are off the charts high needs in terms of mental health, an attorney and a client advocate, although we do our best to educate ourselves, are often in need of the expertise of somebody who has training and experience in mental health to seek the best forms of release plans and care as part of their case. And until we are able to better serve the very small percentage of our clients that are this highest needs category, they also make up the largest proportion of clients who are likely to reoffend, which means more jail time, more clogging up the court, and obviously the detriments to public safety there. And there is a model within public defense. The BIDS office, providing felonies, has a forensic social worker, a mitigation specialist who has a social work background on the defense team to do exactly this kind of work. They're really paving the way to show the value of this in Douglas County. And additionally, a social worker can help provide can do the kinds of evaluations of existing services that I know the county is always trying to measure and figure out where are the gaps here, what are the barriers to entries here. That is work that a social worker does as part of a defense office. So those are our numbers for last year. What questions can I answer for the commission? Oh, yes.
Commissioners who would like to begin? Go ahead, Commissioner Reed.
Thanks, Sam. Well, first question is just have you sent you shared a new PowerPoint today
Yes.
that we do not have in our packet? Has that been shared with staff?
Yes, I sent that to staff. It's all the same information. It was just formatted much more attractively than I was able to do. My co-executive director took a look at my slides and said, these are ugly, and I would like to improve them. The shifting colors on the number of dollars, for instance, but I did share the final version as well.
Okay, so we just need to make sure we've got that in public record, so.
Certainly.
And
I would also echo, it's easier for us to follow along when we have the same
Yes.
presentation, and it helps us prepare better questions.
I do apologize for that.
I wanted to, you may have said it and I may have missed it, but with the civil legal services and the team that you've got working on that and all the case statistics you gave us for that. Are those referrals that can be received from theoretically anyone, or are they only clients that are being appointed to KHD for criminal cases and then subsequently are have others co-occurring civil things?
That's a great question. The vast majority of our civil referrals come from the self-help office and from showing up to the answer docket. So I don't have exact numbers on this, but I would estimate that probably 95% of the individuals we're representing on the civil side are not KHD clients on the criminal side.
Okay, thank you. I probably do have more questions, but I'm going to look back through my notes if other commissioners have anything top of mind.
I'll tag onto that, just the civil work. So what portion of, so KHD is paid for by Douglas County versus, I think we're only paying for misdemeanor defense, is that correct?
That's correct. And so the exact numbers, I'm not sure about, perhaps, we can certainly send that, but essentially, roughly 6 of our staff, the 6 staff that work on the criminal side, are all funded by the county. The 3 additional positions are funded by other grants. And so I would estimate that roughly, 60 to 70% of our funding is coming from Douglas County. Although this doesn't count as well donations, in addition to grants, we also have donors that support our work. So I would estimate that probably around 60% of the work that we do in Douglas County is funded by the county.
Another question about case management. So I know many of your clients probably also have existing relationships with other service providers, either before or during your work with them. What percentage would you say have active case management?
This is difficult to say. I don't have the numbers on this, but I would say that, I guess it also depends on what we mean by case management. So for instance, we do have, I'd say probably about half of our clients who are unhoused are present or are in the course of our representation connected to the homeless outreach team at Burton Ash. There is intensive case coordination, ICC, through RADAC. We had attempted to set sort of a more formal referral stream last year with them, but they had said they were not in a place where they could accept very frequent referrals from us. So I would say that only probably a handful of clients that we work with are working with ICC, RADAC. We do have a good number of our clients who work with the domestic, the Willow Domestic Violence Center in some capacity. I don't have exact numbers there, but that is another point of case management. But I would say that the vast majority of, I'm sure that I've left some provider out and it's going to come to me later, but I would say the vast majority of our clients do not have active case managers. Now, this, in some ways, this makes sense, right? If somebody's coming in on a DUI, a minor in possession of alcohol, they're not in need of case management. But even among the population that I think need case management, or that our client advocate is providing a great deal of case management-like services for, probably only about half of those are either connected before or even after our work with them to a full-time case manager. But I would like to look more into those statistics and get you something more precise than that.
I guess what was kind of driving the question was you've had the conversation both last year and this year about the need for a social worker through KHD, and just wondering like what percentage of your clients are in need for something that is specific to KHD versus needing to be connected either currently or in the future with other service providers.
That's a great question. I mean, I think another, again, I referenced this, but there are a lot of our clients who are banned from Burton Ash, or who other service providers decline to work with for various reasons. So even when we are like connecting people as often as we can, there are still people who are falling in the gaps there. And I guess I should also mention one more thing about that. So for instance, in a variety of situations, people have to get mental health evaluations as part of a condition of probation or diversion. For most of this reporting period, if somebody went to Burt Nash for a mental health evaluation, if they said this is for probation or this is for diversion, Burt Nash was declining to screen those individuals. I believe that that has been corrected since then, but this was something that we were seeing a lot of during this reporting period that made it so that we had to find other service providers to do those mental health services for individuals who required mental health services as a condition of probation diversion.
Did you have a comment, Sarah?
I think Sam corrected it, the issue of assessments has been addressed.
Yes.
And Burt Nash is providing those assessments.
And
So I do
yeah.
think as you're thinking about your numbers for next year, that's probably something to think about. I also would say that we've clarified in our service agreement with Burt Nash that no one is banned from the treatment and recovery center. So crisis services are available.
And I will say the TRC coming online, obviously this reporting period, the majority of this time is when that's not in effect. So we're still seeing the effects of that coming online. And I will say that for the clients who have gotten into the TRC have received really excellent services there. And I'm hoping that happens even more going forward.
Thank you, and I appreciate the clarification that you have. When we talk about being banned from services, that's something that makes me wonder how those conversations go between what you're seeing as, advocating for your client and that organization and working that out. Because when we go to those service providers, that is not a term that they understand, is that they have banned individuals and they push back on that. So I just want to make sure that you're in that conversation. And then when it comes to us, we kind of have a shared language about what we mean when we say that.
Certainly, yeah. Then, and again, this is, I think that there is certainly more to be there. I will say that because the corrections that Sarah has mentioned, I think we're very glad to see those. This is, yeah, I think an ongoing conversation that we are very interested in being a part of.
Commissioner Willie, can I pull on that thread just a little bit? I just want to add that it would be really helpful in the future as some of these changes are in effect and clarification has been understood between community partners, that in future presentations, having some sort of data or some sort of clearer picture around a true number of people who, based on attorney and advocate experience with that client, can sort of confirm, to Commissioner Willie's point, if the status of somebody's eligibility for services that are needed specifically related to their court case is sort of impossible to meet. If there's a barrier that can't be removed through the work that you've done in the time of that case, I think that is important for us to understand, but in more tangible terms, with protecting client confidentiality, of course, but to have a better understanding of sort of what does that mean exactly, and what are some concrete examples of that? Because that's informative for us as commissioners to understand if there are still some roadblocks in place that can be moved. We do want to understand that, but we need to be able to understand it quite clearly, if that makes sense. And then,
oh yeah, can
I just also wanted to add on, I had a clarifying question about, you talked earlier about referrals a lot, and referrals and assessments are usually a court-ordered thing. When you're talking about the referrals numbers that you all make, was that specifically tied to referrals that were born out of a court order, a condition of pretrial or otherwise, or is it sort of a larger catchment of any kind of referral, even if it's not related to a court order?
So this is a really great question. We've actually made, I think, significantly more referrals than that, but the only way that we had, for the purposes of this data, to track and quantify that is by looking at, we generated this data out of court filings, right? And so those court filings give us really quantifiable numbers on that. We have updated our case management system to allow us to better track some of these other kinds of advocate services. For instance, I'd mentioned the vital document thing. That is not something that we have numbers for tracking. Case management system is being developed around being able to track those things. So all we had to be able to present here was things where it was complete. We verified that it was completed as part of a court order. But there are a variety of, a lot of service referrals that would not be captured in this data that we hope to capture going forward. Does that answer your question?
It does, and that's kind of what I expected, but I just wanted to like flush it out and make sure that my assumption about that was correct. And my perspective is that that's the appropriate way to talk about it in this context for us to understand. I'm also interested if you do figure out how to sort of clarify and all these additional referrals for services that are not necessarily directly tied to the court case or a court order, but it feels like your tracking of referrals and the completion of any of those, excuse me, and any assessments that are required along with those referrals, that might be the place to track and understand if and when there's a roadblock from a local provider that has been impossible to overcome through attorney and client advocate discussion. And if that can be articulated and understood more clearly, that will be helpful for us.
No, that makes sense. And that's part of what we're hoping to get out of this Arnold Venture Grant is a full-time data person. Right now, all of our data input is basically, we collect data because attorneys and staff are putting in that data as part of their work, just in the ordinary course of their work, and in the ordinary intakes that we're doing. And so as you ramp up in the data you're collecting, that does exert, sort of a toll on staff to have, in the same way that doctors cite the management of medical records as a big driver of burnout. So we're trying to figure out ways to capture more data without requiring a whole lot more data entry, and also so that the data that gets generated is more accurate and cleaner.
No, it's great. I would actually turn to Commissioner Kelly.
Yeah, this is Commissioner Kelly. I hope y'all can hear me okay. Sam, I appreciate the presentation. It's clear that Kansas Holistic Defenders is making a difference. I want to echo something my other commissioners said earlier, because I think it's really important in working in partnership with people. What was presented in the slides was not entirely what we had previously. And one of those things that was not included in those slides was that people were banned from other providers. It's not in your other slides. And I think it creates a trust issue with your other providers if they haven't seen anything like that before you're presenting it at a public meeting. So I just want to urge caution and ask, Kansas Holistic Defenders, we understand that timelines for presentations are tough, but I think if we're going to make allegations that people were banned from facilities, we need to be very clear on what that was and give the public and other partners the chance to respond to that.
No, and I take that makes perfect sense, and
Okay.
I can absolutely see that.
I just have a couple of quick questions. One is, when you're looking at the co-counsel with bids, are those included in your total case numbers?
So for the data that I just showed you, none of the cases that we handled here were handled with bids, because all of the cases that are analyzed here are at the latest from September of last year, which predates when bids was established. Going forward, so I think the question of co-counseling is a really good one. Can I anticipate, I think, something and respond to that as well? So
Sure, go ahead.
on the question of felonies, so during this reporting period before bids got established, when our clients had a felony of a level that we could take, we would also represent them on the felony. Then when bids got set up, those felonies were going to bids. And then there's also been a temporary case freeze at bids while they get fully staffed now. And so it opens up the possibility again of, should we go back to pre-bids where we're taking felony cases? I think that and we're sort of trying out this relationship, right? You can say that the cases that we've co-counseled with bids have been, it's been really great to have another organization on those, especially because often those who also get a felony are also more high needs individuals, right? So having more hands on deck really helps. But I also know that there are efficiency issues there. So we've been in talk with the courts about exactly what to do in terms of felonies where individuals have misdemeanor cases as well. Bids, because their guidelines from the state are they're not allowed to take misdemeanor cases. And so, of course, there's never been a county that has a misdemeanor office and a felony office, where there are, in other counties, it is typically the practice where there is a felony attorney on the felony and a misdemeanor panel attorney on the misdemeanor. But figuring out the best way to handle those kinds of cases is an ongoing conversation. And we're looking to sort of see about the allocation of resources to be able to meet that need. Does that make sense?
It does, and thanks for the update on the timeline. That totally makes sense to me. I appreciate that. And I'm excited to hear how those conversations go. My other question was, I heard you say we bargained for our first contract, and so I was interested in what employee groups were included in that bargaining.
So the bargaining unit at KHD includes any non-management employees. So not included in the unit are supervisors, that is myself, Tamber, and Rebecca Gaston. Within the unit are 2 criminal attorneys, 1 civil attorney, our investigator, our client advocate, and our paralegal.
Thank you.
I have another question. So of the total caseload or number of people that could be applying for services with KHD, like what percentage are you able to take, either by just volume wise or for folks that you have conflict with or something?
So we've never stopped out due to volume alone. But for conflicts, this number has changed over time. And the reason this number has changed over time is that when we have more clients, we have more conflicts. And it's also fairly difficult for us to track this, in the sense that if we don't get appointed to a case, that case never comes to us, so it doesn't get opened up in our system. I can say that from the data that I was able to, the only way that we would know this is by analyzing all of the misdemeanor filings from the court side and seeing how that matched up to our cases. Within the reporting period, my best estimate for conflicts is it's about 3% of cases. And we don't know how that's going to change over time. It's certainly increased over our first year. It's possible that it sort of levels out over time. It's possible that it increases. I think one really useful metric might be to look at the number of conflicts that bids has as another metric to be able to see what on average does it look like in most jurisdictions for conflicts. But as of right now, my best estimate is about 3 to 5% of cases still go to the panel.
You had mentioned you'd never had to pass on a case due to capacity, but wasn't there a time when you didn't have enough staff to take
That was,
cases?
yes, it's we're not stopping out due to case levels, but only because of if we do not have attorneys, then we did stop out. I believe in the reporting period, there were 2 case freezes, one of which was 6 weeks in roughly August to September of 22, and then another 2-week freeze in the summer of 2023. And so, and those were, those were staff turnover, but we were able to hire people up and get back on track.
I would call that, capacity
Oh,
issues
yes,
because it's also staff.
I would call that, 'cause when I was thinking about capacity, I was thinking about more
Caseload.
like, we are fully staffed and we just have too many cases. But yes, that would be a capacity freeze. I'm sorry,
I think we're getting there. Yeah.
yes.
I guess overall, as I look through the data, the piece that's missing, which I think is partially the piece you're writing the grant for, is I don't have a comparison. I don't have a comparison to the overall, which I would imagine that some of the data that comes from the district attorney's annual report would be relevant if you could, track things in similar ways, to understand, like, even if it's not, this is what happens at panel and this is what happens with KHD, like, this is what happens globally overall, because I think much of that data should be available. And that would give us a ballpark, because I do not know the legal system well enough to know if these averages are, awesome, or if they're, close or on par. Like, I just don't have, within the data, it's hard for me to read through and know what pieces to celebrate especially.
No, it's been, that has been my biggest question as well, is like, I'm really happy with these numbers, but how do these stack
How
up?
do we know? Yeah.
And so, we have partnered with a professor out of Sam Houston University as a partner who is interested in doing this analysis. If I recall, I'm not sure, when I looked at the district attorney's report from 2023, I didn't see misdemeanors data in there specifically. The only barrier is to doing this analysis is just having somebody who can go through all of the court filings to extract the data in a form that can be analyzed.
Do you have conversations with court personnel about their end of the data and how it would help each other?
Yes. And so, for instance, when I spoke with I did tell the chief judge about this study, was very open to sharing that data, and we've reached out to other county staff about other data on questions that we have. But I think one way, there is somebody who's going to want to fund this data because it is so important to answer the question of this particular comparative. We're just trying to find a funder that will actually pay for someone to do the entry and analysis.
All the questions I have for the moment. Commissioners, are there others before we do public comment?
I do have a couple questions. With the probation violations, really appreciate like that data being parsed out and the to understand it sort of separate and apart, but obviously still related to the other cases. I'm curious, I mean, that docket's been going on for more than 6 months now. I'm kind of looking at Katie too, right? To make sure that I'm about right on that timeline. Since BIDS has come online, is BIDS at that docket and being appointed frequently to felonies that you're
Yes.
aware of? Okay. Like, have you run into, are conflicts becoming an issue there yet that you can see where there might be a lack of available counsel at those PV dockets, just from your anecdotal experience so far?
No, I mean, conflicts very seldom happen in probation violation cases, simply because we're not litigating the underlying thing.
Okay.
And so very seldom are we getting conflicts there. It is a smaller proportion of our cases overall.
Sure.
That also explains why. But really the only conflicts are if we currently represent somebody where the individual that we would represent would be a witness or something in their
Or a
case, right?
victim, yeah.
And so those are fairly rare, and I can't speak for bids as their number of conflicts.
Sure.
And I guess I also, the number of available panel attorneys on both the misdemeanor and felony panels has been in flux over this period. But I can say that where we have had conflicts, I do not recall situations where panel representation was unable to be swiftly found.
Thanks. I appreciate that. And I know it's sort of, I put you on the spot there and it's anecdotal only, just curious. I just kind of want to pay attention to if a gap starts to exist there because of, sometimes probation violations are often related to new criminal charges, either for that person or somebody else related. And that, over time, I think there's propensity for possibly more conflicts, but it's also helpful to understand that because you're not litigating the underlying facts of the charges, that also makes a difference. So you may have said it before, but is there like an average number of court dates or appearances on those probation violation cases that you have been able to clock yet? Like how many times you're coming to court on those cases?
That's a great question. We would easily be able to generate that data because that is something that we would have.
Yeah, I'd be
available.
curious to see it, just kind of how it compares or contrasts. And it's a different track and there's different things that can happen, but I'm just curious, like that average number of court dates per disposition, it'd be interesting to see how PV cases move.
Yeah, I can tell you anecdotally, I mean, because we're there at the first probation violation, many probation violation cases, well, not many, but a good portion of them get sorted out that day, right? Right then and there, it's a technical violation. They need to get back on track. They are, the probation officer is willing just to give them another chance and reinstate them right there. Those happen immediately. Most others typically will only have one more court date because there'll be, a 60-day period for them to come into compliance. And then at that second date, they will have either done that or not.
Sure.
So generally speaking, our probation violations have a longer period between the court dates, right? We're going to set this out 60 days to see how somebody does. But the overall number of court dates for probation violations, I think, tends to be less
frequent.
than.
Okay. That makes sense to me. So I thank you for sort of tracking. I was trying to sort of get a grasp on, you mentioned, I think that the PV cases are about 10% of your total cases. That number may very well fluctuate over time, depending on different factors, but trying to get a sense of kind of how much, much additional capacity that has required because there's been a number of additional hearings. So, but it's good to hear that a vast majority of them are able to be resolved sort of on the spot in real time, and that's efficient for everybody, including the courts. I think my only other main question for now is you had the overall average number of days to disposition at 149 at 0.5. And I'm just curious, I mean, that's under speedy trial clock, but speedy trial is a thing again. So I just wonder if you have, I'm just personally curious. We talked a little bit about it during our CJCC meeting last week, and curious from your office's perspective. You're probably not seeing much impact about that yet, but if you're anticipating any impacts of that and how things will process.
Yes, I think it's going to be huge. I think it's going to decrease the number of court dates because right now the court's calendar for a jury trial is backed up into June or July, which means that even for cases that we expect to resolve some other way, the most efficient thing is going to be to set it for that trial date and then try and get it worked out before that, rather than having so many status conferences before setting a trial date. And so I anticipate, and speedy trial has only been back for 3 weeks. And so I anticipate that this will be driving a faster resolution of cases, but unclear about what form that will take.
I'm done, commissioners. Thanks.
Mr. Kelly, any more? Okay,
No further questions. Thanks.
all right. Sam, you've brought a crowd with you. It doesn't show on the screen, but I wanted to open this up for public comment. Is there anyone who would like to address the commission? Or Sarah, you have a question?
I just wanted to insert something real quick. Well, not a question, Sam, so you can, but while you're getting ready for public comment, several of the concepts and progress that's been made recently mentioned, including the PV docket, competency, restoration work, and work on getting a better link to assessments is work that has been done by our district court system and our criminal justice coordinator. And since we've got a crowd here, I think it's important to stress that this is a team effort and there's been a lot of progress in the last year.
And I would definitely love to celebrate that work about the competency restoration, starting at the county level. It's going to be a huge game changer, and I'm really excited for the whole team that's been working on that. Would anyone like to give public comment on this item?
Y'all came just to listen to us. You don't have, I know some of you, you have something to say.
Sarah, do we have anyone online? Okay, last chance. Anyone? Oh. Spoke too soon.
We'll move Carrie Brandon into the panel.
Carrie, you have 3 minutes to address the commission on the Kansas Holistic Defenders.
Commissioners, I just wanted to actually take a second to actually commend the questions that were asked about this regular agenda action item, and encourage you to make sure that if you don't recognize something on the consent agenda moving forward, that you pull it from the consent agenda and thoughtfully put forth the same rigorous questions towards those consent agenda items before approving them. And I think that the other thing that I would love to get a response on with regards to, asking good questions on anything that's on an agenda would be, if a consent agenda item.
Carrie, this is about the Kansas Holistic Defenders item. We have passed that other part of the agenda, but it will come back again next week if you would like to try that. So do you have anything further to comment on the Kansas Holistic Defenders report?
I just appreciate Shannon Reed's questions, and I just want to make sure that all agenda items are addressed with this kind of rigor. Thanks.
Thank you. Do we have anyone else online who'd like to speak?
Do not.
Okay, that will close public comment, bring it back to the commission. I don't think we have an action item. This is information purposes only. So with that, we are finished with our regular agenda. We'll move into appointments. And Sarah, actually, would you like to start with your memo, or we have some appointments to pull up?
Well, I did want to check with commissioners on appointments. We've had a couple of reappointments coming up, and I just didn't know if the commissioners needed more time. I'm going to try to pull them up myself.
I have one.
Okay.
I am very happy and proud to put forth John Harris for the Fire District Number 3 Board. He and I have served together for 10 years in that capacity. He's a great firefighter. He stepped down from that role a couple of years ago and has great ideas for moving us forward. He works actively with emergency management at the county and is just going to bring a lot to the table for that. So I would very glad to nominate or move to approve John Harris for the Fire District Number 3 Board.
Happy to second that.
All right, we're going to move in second. All in favor?
Aye.
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 Thank you. Motion passes. Do we have any other appointments?
I mean, there is the reappointment on the Health Board. I'm going to try to pull that one up. Here we go.
I've not yet reached out to Erica Dvorsky and would love to have a conversation with her before reappointing.
Commissioners, this is Commissioner Kelly. I'm meeting with her on Friday.
Got it.
Okay.
Thank you.
I appreciate knowing that because I've had some questions from the health department and they'd like to proceed with that. Okay. I think that we also have an eligible reappointment for the Heritage Conservation Council. If somebody wants to reach out to her,
I'm looking.
it's Patty Beatles.
Oh, got it. Yes, I can reach out to Patty.
And I think that's probably all I've got pending at this time.
Okay. Okay, and do you have anything else for our memo, Sarah?
Yeah, commissioners, attached is your memo. I'm going to go back to my screen to find it. There have been some, just want a reminder that next Wednesday we have the canvas for the presidential presidential preference primary. Next Wednesday, will all three commissioners be able to attend?
Yes.
Yes.
Okay, great. And then we've added a date for a drug court graduation. Also, we have reassigned the July judges luncheon to July 8th. That will interact with our budget process. So I anticipate we'll probably end early to make and drive back since we'll be out here for budget preparations and make that work. But that's a change I want to make sure you have on your calendar. Also, commissioners, I had our tax team put together some information related to state assessed properties. And this is just kind of background state assessed 101. I thought you might find it beneficial. So if you have some time to take a look at it, it's really just like 3 or 4 slides. Before next week, I think you might find it helpful. There is some specific information on state assessed related to the Lawrence Energy Center. So for those that might be listening, the very exciting world of state assessed taxes are generally public utilities. And so it is assessed by the state Kansas Department of Revenue Property Valuation Division. And we locally don't have any say in that. And there's a different valuation method that's outlined in that presentation. And there's a lot of variation. As you can tell, when you look at some of those numbers can swing pretty widely. And it is because they take in sort of utility revenues and expenses into that calculation. And most assessed property assessments don't include those. So there is some change into those. So just wanted to call your attention to it. And if you have specific, and overall, it's about 9% of our tax base in Douglas County. So it's important to talk about. So just let us know, commissioners, if you have any questions on that particular item.
Well, I am super excited to have this. Actually, this is one of the things I've been asking about since I came in, and it's given to us as the state as this kind of black box number that we don't have any control over, and just wanting to better understand what those pieces are, especially as we talk about Lawrence Energy Center and its, a limited lifespan, whatever that might be, as of, they keep saying they're going to close it every few years, but what that will do to our tax base, and that's another piece that I'm really curious to have. So thank you for pulling this together, and really excited to get to talk more about it.
Yeah, and I can have the members of the tax team come if you want to get into more detail about it. So just try to take a look at it and let me know.
Thank you.
And do want to, we did include the link for the Criminal Justice Coordinating Council's March 12th meeting discussing jail-based competency restoration, and included a link to that meeting, and was really excited to hear about the work coming out of that. You also have your weekly Little Government Relations report, and that is, and just a reminder, commissioners, next week, we will be back out here at Public Works, and we'll be starting early at 3:30 for the staff presentation and the applicant presentation on the Kansas Sky Center. So we're starting earlier than usual and out here at Public Works, and that will be a work session environment, so there won't be public comment, but we have a pretty robust packet. I think you're going to be over 1,000 pages. I hate to say it. Yeah, so some of that is the original Planning Commission packet, but I hope. But so I'm putting that packet together now, and then we will be back out here for that presentation.
And just for the
next
public, that packet will hit probably Thursday or Friday?
It'll probably hit Friday afternoon.
Okay,
I'm
thank you.
hopeful. I'd hoped to be able to release it early, and we've just had some up to the minute, last minute changes, and I was not able to get that packet out early. Commissioners, that's all I have.
I had a question. I know there was, you had brought to us a report of a Johnson County program for a low-income tax credit done at the local level, and that's been of great interest. So I think maybe that's still in the works. And can you kind of give us a timeline of when we might have some details to share as a commission or to talk about as a commission?
Yes, actually, the program that Johnson County implemented is a rebate. So individuals pay their taxes, and then if they meet certain income guidelines and other qualifications, then they're eligible for a rebate. The administrator's office has been working on that with the county clerk's office, and I'm hopeful that we can. Election day was yesterday, so hopefully, once we get past the canvas, we can have a conversation with the clerk's office about when they're ready to come in and present that item. But I think it's going to be within the next 30 to 60 days, commissioners, definitely before budget.
Yeah, it'll be exciting to hear more about that. And then as far as a timeline, when the earliest that could possibly be rolled out, is that probably next tax year?
Yeah, tax years are constantly overlapping and in process. So the recommendation from the clerk's office is to make that eligible for application in January of 2025, based off of taxes that were from the prior year. So it will be on the taxes that in essence, folks are getting assessed valuation notices on now, and then we'll have to pay taxes later this year. I think if I've got my tax year calculations right, so don't quite hold me to that, but we're looking to start the program in 2025.
Well, I'm really excited for the update, and we'll be glad to hear more when you're ready. So, thank you. Commissioners, do you have anything else?
Sarah just mentioned it again, and it came up a little bit during our earlier agenda item, but wanted to just shout out the CJCC meeting last week and what I thought was a really well done presentation by our coordinator, Katie, that just boiled down a lot of information for people who may not be familiar with the challenges that we have faced with competency restoration and the time that it takes, and working with the state to mitigate that as much as possible. The presentation was really well done. So if you haven't seen it yet, and I think there was some great conversation after the fact, it was, Katie, you managed to be both super informative for people who have no idea what the topic at hand was, and to give really good sort of new, detailed, and straightforward information for stakeholders and those of us who do know what the challenges have been and are hopeful about what this new program and collaboration will look like. So I'm I'm very eager to see what the results of that will be, and thankful to our state partners for working to come up with alternative solutions to the bottlenecking that just sort of won't let up at Osawatomie State Hospital.
I appreciate you including the link so that I can, because I was very excited to hear about the work, and now I'll get to know a little bit more about it. So thank you. Any other items for tonight? Okay, with that, we are adjourned. Thank you, everyone.